Welcome back, everyone, to another episode of C4 NPR Chats. I'm really delighted that Patty Wise is back with us, a local attorney with Spangler Nathanson. And I know a lot of you, perhaps a record number, looked at the YouTube video and listened to what Patty had to say with her initial briefing that she gave us, legal and employment matters related to the coronavirus situation, particularly here in Ohio. So Patty, welcome back.
Thanks for having me.
Yeah, and I know Patty and her colleagues have been working feverishly in about the last 21 or 22 hours trying to make sense and understand some of the legislation that's been passed and at the federal level. And we will certainly get to her opinions and comments on that in just a second. But Patty, let me just ask, I know that you have a pretty long reach into our community. What are you noticing or hearing or seeing in terms of employers and their relationship with their employees here in the Toledo and surrounding areas with relation to the coronavirus situation?
Sure, and it is so fluid. So we're up to the minute here as best as we can be. It's probably changing while we're on the call. A couple of things though, and it's interesting you should say that we're working feverishly because hopefully we're not. But two things to that point. The question I'm getting a lot is, should employers be scanning employees' body temperatures? And if you've been able to follow the governor's, he does a press conference every day now, and he has been advising, I would say strongly advising. He has suggested that perhaps there could be sanctions eventually for this, but he has been saying that employers should do a body temperature scan every single day when employees report to the workplace. Now, some people listening might say, well, wait a minute, I don't think we can do that, and they would be correct in a normal situation, but not in the emergency situation we're in. And they're probably thinking of the Americans with Disabilities Act and EEOC regulations implementing that act, because that would ordinarily be a medical exam. In this case, one, because of the emergency, and two, because of the purpose, it is not considered a medical exam. And by the purpose, what I mean is that employers would be using this to test only for the temperature because a fever has been indicated as a symptom of the coronavirus. And so we're not making any kind of diagnosis. We're not suggesting that someone has a condition, but we are testing, if you will, for one symptom, and it's not a perfect correlation. So it's not to say that anyone with a temperature has the virus. We're not medical practitioners. We're going to have false positives, other explanations, false negatives, but it is, in fact, a symptom, and it is one of the ways that employers actually can test and have some degree of, hopefully, some reassurance that they don't have the virus. So when we do that, though, and these are the kinds of questions when, that's one thing to say that we should be testing for temperatures, but we should be testing only with the forehead scan, and that is not only non-invasive, but there's no touching involved at all. So it's literally a thermometer that's held up to an employee's forehead. The person taking the temperature should not be a supervisor or manager, someone in human resources or someone with operational responsibilities. And one thing I really would stress is the temperature taker should be prepared for the results. They should be very calm and dispassionate. So if the temperature does not indicate a fever, and we're just talking about, generally a fever, so that's considered to be 100.4. I would say 100 is a good cutoff. If a temperature is not elevated, again, really no response. Here's the temperature. This is what it is. Go ahead, go to work. If it is 100 or more, the employee needs to be sent home right away, told to contact their healthcare provider, and then some additional cleaning probably in that employee's area would be appropriate. And it's really important that employers not record the results. So in other words, don't make a chart. We've got 12 employees. here's their temperature on Monday, here's their temperature on Tuesday. Do not do that. That's could potentially be a HIPAA violation, could turn it into a medical exam. We're just looking for employees coming in the door. Do you have a temperature today? Then you need to leave. And do you not? Go to work. And not, I'm not letting you ask any questions, but that leads me then to kind of a second issue, a second concern, and that is, can we send employees home? Can we require employees to be working remotely? And I will say, I am telling all of my clients that employees in non-essential positions absolutely need to be out of the workplace. They should be working remotely if they can. If that's not possible, we really need to get them out of the workplace. In particular, to your question, Heather, about this area and knowing this community, we've had a death. Someone who was in the workplace as recently as last week, who passed away this weekend. So if anyone thinks this is not very serious, that it's simply wrong. We're in the mitigation phase. We should be, if anything, overreacting, trying to flatten the curve. We've all heard that term now. So it's just critical that non-essential employees not be in the workplace, and that is the advice I'm giving to all my clients. And I will stop talking and let you get a word in edgewise.
No, I appreciate that, because those are two really critical points, and there has been a lot of confusion, a lot of questions in both scenarios. One follow-up question, you may think this is obvious, but what is deemed to be essential at this point?
Right, and that's going to vary for every employer. I think we're going to get, more and more clarification. We've seen the governor closing different, types of businesses, but for every organization, we've got organizations who are feeding people and organizations who are considering grant applications, obviously, very different, but each organization, each nonprofit is going to have to say, this is absolutely an essential service and it has to be delivered. And conversely, here's something that might be delayed, might not be working as smoothly as it usually does. I truly don't think there's going to be second guessing of this. I think the only second guessing we'll see is when, we're not allowing employees to work from home or requiring them to come in and face exposure in positions that aren't essential.
Okay, so let's pivot a little bit. And oh, by the way, if anyone has any questions at all, Patty has graciously agreed to take a look at them. So if when you're listening to this presentation, if you want to jot down a short question or a couple and send them into info@c4npr.org, we are monitoring those and we will get some responses out. And if you have the question, probably someone else does too. So
that's right. And Heather, if I could add to that,
Sure.
I'm not able to give, answers to specific questions about specific situations without an attorney-client relationship, but definitely, I think Heather is so right. If you've got a question, probably others do. So if you could just ask it in kind of a general way, more a hypothetical situation, that would be great.
Great. Thanks for clarifying that. So, Patty, when you take a look at what's been happening at the federal level, what do nonprofit leaders need to know about the new federal legislation that just went into effect in response to the coronavirus?
Right. So this is the Families First Coronavirus Response Act. And so the FFCRA, for those of us who like acronyms, it was passed fairly quickly, signed into law last night. It provides a variety of things, some more kind of welfare, health, safety, the good of the community, so free coronavirus testing, enhanced Medicaid funds, enhanced protections for healthcare workers, those kinds of things. In particular, for employers, though, there are two aspects of the Response Act that will be different. One is a section called the Emergency Family and Medical Leave Expansion Act, and this is a set of additions to family and medical leave. So, you know, some of your listeners will be saying, "Oh well, you know, FMLA, fortunately or not, it doesn't apply to us because we don't have 50 employees. We don't meet the cutoff." I will tell you that now the amendments to FMLA for this particular situation apply to every employer with fewer than 500 employees. So those of you who might have been maybe blissfully unaware of the provisions and requirements of FMLA are going to have to understand these particular amendments for this situation. And these amendments go into effect on April 2nd, and so they will apply to every employer under 500. You know, there are some exceptions. Financial hardship might be something that would be considered for those employers who do have fewer than 50 employees, but it is, that's, you know, there will be regulations about that, and so I couldn't at this point say that anyone would or would not be exempted from these provisions. And Heather, I think you've said that that's something that's going to be posted on your website. I've done a summary of that, and again, we'll see regulations, and the DOL will be coming out with posters about it, but really everyone needs to be getting familiar with this new act. Part of the Response and Aid Act was also to enact something called the Emergency Paid Sick Leave Act. That also becomes effective on April 2nd, and that too will apply to employers with less than 500 employees. That's going to require paid leave of up to 80 hours for full-time employees and 2 weeks for part-time employees based on their average hours. Again, I've summarized that. I think that will be available on your website. But these two aspects of the Relief Act are critical for employers, and you've really got to get familiar with these. Now, there will also be some offsetting tax credits for these paid requirements. So the FMLA, for example, we always think of FMLA as being unpaid. This particular new addition to FMLA is paid. And so that's something that employers will have to fund. And again, tax credits to offset that, but everyone needs to be get familiar with these new laws.
Yes, so the reference tool that Patty has mentioned, you can find in our blog, the Gearing Up blog. It's off of our main menu. If you just click on that, we'll also put a link on the main page so that you can find it easily. But that piece, Patty is a guest blogger on our blog series, so absolutely, that will be available. Okay, so what, if any, other legal requirements do you want to discuss today, given the current environment?
Frankly, there are so many. One in particular for Ohio, in addition to the temperature requirements, we have had, I think, an excellent reaction from the state in terms of unemployment compensation. And so any employer who is in a position of laying off employees or maybe cutting hours, those kinds of things, you should be giving the information to your employees in that situation. And there's actually a code for mass layoffs. You should be giving that to them. The 1 week waiting period has been eliminated so that people can get compensation right away. And so that is critical. In terms of federal laws, truly almost everything is applicable to this situation. Just to kind of touch on a few, OSHA requires all employers to provide a safe workplace, a workplace free from recognized hazards. I would say that's another reason kind of supporting remote work. But we've got people doing jobs that are not necessarily routine now. So even someone who's doing their same job might now have additional cleaning duties. And so, OSHA can come into play with that in terms of chemical exposure. The one thing that everyone needs to understand about OSHA is that the coronavirus has been designated as a reportable event for OSHA purposes. So that annual report that's required for OSHA needs to include any diagnosed employees who have the virus. That will potentially have workers' comp implications. We don't know yet, too soon to know that. And the difficulty there is we won't know necessarily, we probably won't know whether an employee has gotten the virus because of work exposure or somewhere else. So that's just that. And we may want employees to have coverage through the workers' comp system. So that remains to be seen, but just understand that OSHA does apply. Certainly the Fair Labor Standards Act applies in terms of paying hourly workers if they're working remotely. We only have to pay them for hours they actually work. I will, Heather, maybe we can talk after this conversation. There is a great resource that the DOL has provided about compensation issues specifically related to this virus. And it's a really excellent resource for employers and the kinds of questions they're going to have about compensating employees during this time. So that's very important. We talked a little bit about the ADA in terms of taking temperatures. FMLA, in addition to the new provisions for those of your nonprofits who have more than 50 employees, they still need to comply with FMLA as we know it. So these emergency provisions are in addition to those requirements that they already have. And one other federal law that I can think of that's significant at this time is Title VII. Because of the region where the virus originated, we should be careful in our workplaces that we don't have derogatory comments based on stereotypes having to do with national origin. And I will say very clearly, regardless of who the speaker is, the words China virus or Kung flu are not appropriate, and those would be problematic under Title VII.
Okay. Yeah, it's a lot, isn't it?
It is a lot.
Okay, yes, and if you can pass along links to other valuable resources that can help our leaders, that would be great.
Yep, I sure will.
We'll push those out. So, Patty, is there additional new legislation being discussed that might also be designed to respond to a response to the coronavirus?
Yeah, there is, both at the federal and the state level. So I think that we're going to see one and maybe two additional packages from the federal government. And Mike DeWine, again, has mentioned several things, and I really do think they have been very good. I don't know if anyone's had a chance to watch Dr. Acton each day in the governor's updates, but they really seem to be, on the forefront of this and making decisions, and I think we'll see more and more legislation or directives coming from the state as well. Again, it changes hourly, if not more quickly.
Okay. Well, I think it's safe to say we are likely to have you back for another session. Is that right? I'm happy to come back, but I'm encouraged to hear that we might have, some drugs possibly that address this. I just hope we all are, it's better than anticipated at this point. So I'm happy to come back, and I hope that I don't need to, at least very much. Okay. So again, a reminder, if you have questions, you can send them to info@c4npr.org. I also want to mention one other resource for local nonprofits that's come online. The Greater Toledo Community Foundation has established the COVID-19 Response Fund. It's designed to support Northwest Ohio and Southeast Michigan nonprofit organizations as they assist in responding to the spread of COVID-19 in the community. and experience financial challenges in doing so. You can also learn more about that funding opportunity on our homepage at c4npr.org. And I'd like to thank the Toledo Bar Association for their continued partnership to help produce these legal-related briefings. And of course, thank Patty Wise very much of Spengler Nathanson for her time and expertise. Thank you very much, Patty.
Thank you, Heather.
Yeah, so we will talk to you all again in another episode. Thanks.